2024, and the Board on Professional Responsibility is convened in the matter of Jeffrey B. Clark, board docket number 22 BD 039. Will the parties identify themselves for the record, please, starting with disciplinary counsel?
Hamilton Fox and Jack Nestor for the Office of Disciplinary Counsel.
Thank you, Mr. Fox.
Good afternoon, members of the board. Charles Burnham on behalf of Respondent Jeffrey Clark, and with me is Counsel Perry.
Thank you, Mr. Burnham. Let the record show that Dr. William Hindle, who is one of our public members, is not in attendance today. Our board rules, Rule 13.6 specifically, allow an absent member to participate in the decision of the board by listening to the recording of the oral argument, absent an objection from respondent. Counsel for respondent, may I ask you, do you object to the participation of our absent board member?
No objection.
Thank you. So we're here on exceptions to the hearing committee report from both respondent and disciplinary counsel. As addressed in our December 17th order, disciplinary counsel will argue first, followed by respondent's response, disciplinary counsel's rebuttal, and respondent's rebuttal. The parties may also please present argument on respondent's motion to supplement the record for judicial notice and or to treat factual questions as conceded. Respondent has also raised certain potentially case dispositive procedural and jurisdictional arguments that are unrelated to the underlying facts. We expect that the parties will address those potentially case dispositive issues in their oral arguments. The board will address those issues in its report and recommendation to the court. We want to be clear that our consideration of argument regarding the underlying facts does not suggest that we have resolved respondents' other case dispositive arguments. Disciplinary counsel will have 30 minutes. Mr. Fox, do you want to reserve some of that time for rebuttal?
What I prefer is to, if there's anything left, I'll reserve that.
Okay. Respondent will also have 30 minutes. Do you now know if you want to reserve a specific amount for rebuttal, or would you like to do with what counsel is doing, disciplinary counsel is doing?
10 minutes, please, Madam Chair.
So let's proceed with disciplinary counsel.
Ladies and gentlemen of the board, it's my intention to address three issues, although obviously I'll respond and invite your questions on any matters. But what I would like to address first is the merits of the disciplinary case, focusing primarily on the allegations about attempted conduct involving dishonesty. And I will touch at that point on the motion with respect to the new evidence. And then I want to discuss the impact of last summer's opinion in Trump versus United States. And finally, I want to talk about sanction. With respect to the merits of the case, I want to focus primarily on the statement in the so-called proof of concept letter that the Department of Justice had identified significant concerns that may have impacted the outcome of the election. I hate using impact as a verb, but that's the way it was used in the letter. And in assessing whether the attempts to send that letter were conduct involving dishonesty, I would urge that you look at the continuum of the content, because Mr. Clark's position, particularly before the hearing committee, was to focus only on one aspect of the conduct. The discussion on the December 28th, when he first submitted that letter to Mr. Rosen and to Mr. Donahue, in which he consistently took the position that an attempt to send a letter that was never sent could not possibly be a disciplinary violation. A position that we perhaps have not really disagreed with, because what we have said is that it's the continuous process that he went through over the next approximate week, and that you can't just take a snapshot on December 28th. You have to look at the whole process.
So, Mr. Fox, are you saying that, because I think I had understood your papers to be saying that the violation really was born on the 28th when respondent continued to pursue sending the letter, having been told that it would contain false information.
That's correct. That's exactly right. It's what we've said consistently is that if we had just proffered that letter on the 28th and that had been the end of it, we wouldn't be here today. But it's what happened afterwards. Now, I should say that Mr. Clark, in his brief before the board, has taken a new position, one that he did not take in front of the hearing committee. And that is that at the Oval Office meeting on January 3, all that was going on there was a discussion among lawyers about a legal issue in which Mr. Clark was, as he is required to do under the rules of professional conduct, giving the president his best advice. And so he takes two snapshots. December 28th, then we're just sending a letter, which never went anywhere. January 3 at the Oval Office, we were just giving the president advice. And if you look at the continuum of events, what you will see is that from December 28th through that Oval Office period, Mr. Clark not only continually urged that this false letter be sent, but he ratcheted up the pressure to do so. So, for example, on December 28th, when he met with Mr. Clark and Mr. Rosen, he pointedly told them that the president was thinking about whether the Department of Justice needed some new leadership. Mr. Clark and Mr. Rosen, Mr. Rosen and Mr. Donahue being the leadership at that time. When he came back to them on January 2, having met with the president again, he told them that the president was prepared to appoint him to the acting attorney general, but that he would not accept that position if they would send the letter. And he would give them until January 4 to decide. They told him right on the spot, we're not sending a letter. And so he came back the next day and said he's not going to wait for January 4 anymore. He's going to accept the position. This is January 3, Sunday. He's going to accept the position today. Oh, I'm sorry, I can't see you.
Okay. So our rules here at DC, Mr. Clark was positioning or he was proposing a particular course of action. So our rules here do not permit lawyers from having, let's say, a bad idea or disagreeing with their colleagues or superiors regarding when appropriate course of action. Do they?
Yes, there is nothing wrong with disagreeing with your superiors or colleagues. But you've got, it's Senator Moynihan's famous position. Everybody's entitled to their own opinion, but they're not entitled to their own facts. And what happened here, and I think actually the next point that I'm going to get to, is that after December 28th, Mr. Clark never asserted any factual basis whatsoever to support this claim that he had identified significant concerns that may have impacted the election. So to just finish my point on how the pressure was ratcheted up, on January 3, he says he's going to accept the position if they don't send it, or he was going to accept the position because they told him they're not going to send the letter. Mr. Rosen insists on a meeting with the president. At that meeting with the president, every single lawyer says he can't send this letter. It's a murder-suicide pact. There's no basis to send this letter. Mr. Clark never offers any specific allegations he wants to investigate. He continues to insist that they send the letter. And even when the president says, not because he thinks the letter is false, but because he doesn't think that the political blowback can be tolerated, Mr. Clark continues to insist on sending the letter. And this dishonesty was intentional. As I said before in response to Ms. Hicks' question, December 28th was the last time that he ever identified any specific allegations that he thought needed to be followed up on. And the reason for that was that the most knowledgeable people about those allegations, Mr. Rosen and particularly Mr. Donahue, said, we've already looked at them, including the Senator Lincoln report. We've already looked at all that stuff. There's nothing there. Indeed, he's claiming in the letter that there are significant concerns when the Attorney General of the United States has twice publicly said there is nothing in any of these investigations that would affect the outcome of the 2020 presidential election. And so after that time, and there's a finding on page 167 of the hearing committee of this fact, after that time, Mr. Clark offers nothing. Nothing, and he never offered anything that they had not already looked at. He just continues to say, well, there are things that need to be investigated. And the fact that he never offered anything, any that needed to be investigated, I submit to you is evidence that there was nothing there, that he knew it and that the letter was dishonest.
Mr. Fox, so what do you say to the testimony that we have in the record from these individuals, attorneys who had worked with Mr. Clark for a long time, who knew him, who said that they felt that he believed what he was advocating?
Well, what I think, what I submit to you that says is that he believed in the cause that he was advocating. And I don't think there's anybody that disputes that. But he did not testify. The hearing committee did not judge his credibility. He did not testify substantively. The hearing committee did not judge his credibility on this. And I submit to you that his inability to articulate, even to those lawyers who said they thought he was sincere, what it was that he needed to investigate shows there wasn't anything. And there's more than that. For example, what do you argue to make of the fact, other than he didn't care about what the truth was, that he refused to talk to the United States attorney in Atlanta, who was the person who had conducted the investigation in Georgia? He was instructed by Mr. Rosen to do that on the 28th. Mr. Rosen followed up January 1 by sending him, reminding him of that and saying, and here's his personal cell phone number, and he never, ever did it. Now, willful ignorance, at least in the criminal law, is evidence of intent. And I submit to you that he can't articulate what it is that he wants to investigate, and he won't talk to the U.S. attorney who has actually conducted the investigations, is further evidence that this was not done in good faith. This was just done as a way to disrupt the election process.
Mr. Fox, I get your argument that you're making, that failure to talk to the United States attorney and failing to proffer forward facts that need to be investigated can go to whether or not there was dishonesty or an attempt at dishonesty. Can you elaborate on your argument that you made earlier, where it seemed to be that you were suggesting that placing pressure upon colleagues in the United States attorneys or the Department of Justice also is indicia of some sort of attempt at dishonesty? Can you tie those ideas together? Because I did not follow that portion of your argument.
Well, because I didn't articulate it very well. But what I was suggesting wasn't necessarily that that was evidence of dishonesty. What I was suggesting was that you can't just look at this from Mr. Clark's snapshot perspective of, hey, I tried to send a letter on December 28th. He's never sent, no harm, no foul. That he continued to do that. And then what I'm trying to articulate now is that while he continued to do that, he had no factual basis to do so. And therefore it was a dishonest statement in the letter to say that there were significant concerns for the department. For example, and incidentally, he not only made that claim about Georgia, he made that claim about other states in which he never articulated any basis whatsoever. But for example, we subpoenaed from him any documents that he might have that would show that he had a basis for making that statement, and he refused to produce any documents. He said that would incriminate him. Now, it wouldn't incriminate him to produce the documents if he had them. What would incriminate him is if he responded to the subpoena and didn't have anything to support it, which he didn't. And
you're asking us to make a negative inference from that?
I certainly am.
And what's the precedent here for doing that?
Well, the hearing committee said, the court said in the cases decided already that it left the issue open. The hearing committee said it believed it could make the inference, but declined to do so. And I suggest to you that that inference needs to be made. It also needs to be made from the fact that when I specifically asked him on the witness stand, what are the facts on which you were relying when you say there were significant concerns? he wouldn't answer that question either. And I believe in a criminal matter, in a criminal case, you can't make the inference based on assertion of the privilege, because by making the inference, you're doing the very thing the privilege doesn't allow you to do, using that to incriminate. We're not asking you to incriminate him here. We're asking you to draw the logical inference that anybody would make when somebody refuses to answer a question on the grounds of incriminating, that he didn't have anything to support those statements.
Couldn't, I think the hearing committee may have taken a broader approach, which was, well, because there was a criminal case pending, that he was kind of perhaps taking a prophylactic view of the Fifth, and that therefore that kind of undermines the ability perhaps to draw a negative inference.
That's correct. But that, of course, is not what the Court of Appeals said had to be done in the disciplinary case in the bar situation. They said you can't just take the prophylactic view like you can in a criminal case and not get on the stand. You've got to object on a question by question basis. And I submit the only reason that makes any sense is if you can draw an inference from the particular questions that to which the witness invokes, that the answer would harm his case in the disciplinary process.
But Mr. Fox, wasn't there I have to push on this, wasn't there a criminal case pending all this time against Mr. Clark?
Oh, yes, there was. And I.
So if that's the case, didn't you present it with the options choice? That is to say, he could open his mouth and testify in the disciplinary proceedings, but that would compromise the free exercise of his right not to provide evidence in the criminal case that was pending against him.
I take your point.
Doesn't the Supreme Court's decision in Lefkowitz versus Cunningham say that options choice is impermissible?
I don't think it says so in the context of this proceeding. I mean, look, you've been there, Mr. Tiger, and I was there once myself in dealing with a parallel proceeding situation. And it's a very uncomfortable situation for any lawyer and client to be in.
I argued Lefkowitz versus Cunningham, and I think the court made the point that I have questions about.
I'm sorry, I couldn't quite hear you.
I argued Lefkowitz versus Cunningham, and the Supreme Court agreed with the implied basis of my question.
Well, but nobody has ever said, as far as I know, that when a person is faced with a parallel proceeding, they've said you can't compel him to to answer the question if it would incriminate him in the criminal proceeding. But they haven't said that you can't draw the inference. And the Court of Appeals specifically said in this case that was an open issue.
So, Mr. Fox, can I just get you to, just in like a very elementary way, if we decline to make a negative inference from respondents' decision to invoke Fifth Amendment privilege, what are your strongest points in favor of a finding that he acted intentionally? Because the hearing committee found recklessness.
So I've articulated some of them, but let me just reiterate. One, his failure to ever identify what specific matters needed to be investigated. And the fact that he was claiming this about not just Georgia, but other states, in which he never said anything about that. His refusal to speak to the United States attorney. His failure to look at any of the investigative files that the United States attorney had, which he could have done if he had asked the U.S. attorney about it. To continue to go on, he produced extensive witnesses in this case. None of them offered any testimony about information that Mr. Clark had within the December 28th and January 3 period that we're dealing with here. And he claimed, when he is as one of his excuses for not speaking to the U.S. attorney, he claimed there was some unnamed bail bondsman from Atlanta who had given him some information. He never called that person to testify. And since he never identified him, nobody else could call him to testify either. And finally, I think you can infer from the fact that President Trump was openly telling Mr. Rosen and Mr. Donahue just say the election is corrupt and leave it up to me. They wouldn't do it. And I think you could infer that the president found somebody who would do it. And that was Mr. Clark.
Mr. Fox, can I get to another point? That is, I'd like to know how the hearing committee's determination that Mr. Clark's conduct became an attempt to commit dishonesty only on January 3rd, 2021, when the president, when only the president's rejection prevented him from sending the letter. Do you disagree with that determination by the hearing committee?
I was gobsmacked by that determination in the sense that I didn't think didn't seem to me to make any sense.
But wasn't it based on your statements in your closing argument and that you would not have pursued this case had he changed his mind before that point?
No, well, it wasn't. There's a footnote there that said what I was trying to articulate then, and I said, I'm not sure what the answer is. I think the answer is probably no. And I think the reason that it would never have gone is that we had never come to anybody's attention at that point, if that had happened. But I don't even understand the argument. I have a condition that makes my left eye weep, so it's not that I'm in agony here.
That's okay.
I articulated throughout the process, including the opening statement, including in things that we filed beforehand, that it was the whole course of conduct that gave rise to these charges. And I continue to take that position. But let me say one other thing. There is the statement in that letter that, and everybody interpreted this way, that in Georgia, on the appropriate day, 2 sets of electors had assembled and 2 sets of votes had been sent off to Washington. That's a false statement. It never happened. Now, this brings me to the thing I wanted to touch on, was this new evidence that was offered on Monday of this week, with no suggestion why it shouldn't have been offered before. One of those pieces of evidence is an archive link to the unofficial certificates that people sent into the government. This is now cited as proof that there were 2 sets of votes. These say certificates, but we'll treat them as the same, that were sent into the government. This was never articulated at the hearing. We never had an opportunity to respond to it. But if you look at the January 6th report, Chapter 3 of the January 6th committee, which is about the fake elector scheme, what you'll see is that there were fake electors that were submitted, fake votes that were submitted. In fact, some people have been indicted for submitting those fake electors. But this is not what Mr. Clark never contended that was what he was talking about at the hearing. Everybody at the hearing understood this statement to mean that there had been some sort of official procedure in Georgia where 2 sets of electors were established and 2 sets of votes were sent off to Washington. Not that some individuals had themselves sent their own votes off to Washington. And that's a completely new argument. It's a false argument, and one that we've never had a chance to address because it was only introduced on Monday of this week.
When you say everyone believed what you just said, that we were talking about basically certified slates of electors, your basis for saying everybody believed that is what?
We argued it that way. The hearing committee found it that way. Nobody argued it differently. The only argument I think that they ever made was, well, we never said they were certified, which is technically true. They weren't certified by the government. But nobody ever made an argument that they're now making. So having said that, unless there are other questions on that, let me turn to Trump versus United States.
But Mr. Fox, one question on that. So in other words, the proof of concept letter contains a representation that there were repeating slates of electors appointed in Georgia.
Yes.
Okay. And what you're telling us here is that it was always clear that that statement meant two certified competing official slates of electors.
Yeah, let's leave the word certified out
Okay.
because that the governor had only certified one, but but official, yes.
All right.
All right. Now, Trump versus United States. The Supreme Court was not intent in Trump versus United States to encourage criminal acts committed out of the Oval Office. That was not the point of the case. What the case talks about eliminating the president and uses words like fear or concerns that he might be prosecuted after he left office or something that he did. And there's 4 or 5 pages in the opinion that balance those fears and concerns with the need to prosecute criminality. And the Supreme Court goes for the lesser of two evils in its judgment. And it says that under these circumstances, the lesser of two evils is to not allow the prosecution to say that the president's immune. But he speaks only of the president. There is not one word in the opinion about subordinates or staff or anything like that. And one of the reasons for that, it makes the point that unlike the judicial branch and the legislative branch, the executive branch is one person in the Constitution. There's no suggestion that aides or subordinates have any immunity. For example, if to make a complete hypothetical, if the president in his office with his subordinate says it's a good idea to burglarize somebody, or it's a good idea to obstruct justice, there's been no suggestion whatsoever that aides who actually went out and burglarized somebody or obstructed justice would be immune from prosecution. To the contrary, look at the case of Nixon versus Fitzgerald and the companion case of Harlow versus Fitzgerald. Nixon versus Fitzgerald was the case that established that the president had, in its 1982 case, that established that the president had civil immunity for official acts. Companion case, Harlow versus Fitzgerald, was brought against the president's aides who for the same civil misconduct. A civil case brought against him based on the same conduct. And that case held that public policy does not require a blanket recognition of absolute immunity for presidential aides in performance of their duties. So, and Nixon versus Fitzgerald is one of the foundation of the Trump case. And it says the immunity goes to the president. It does not go to his aides or to his subordinates. In the oral argument in the Trump case, the hypothetical that everybody was tossing around was whether the president could order some military unit to go out and assassinate a political rival, and whether that would mean the president was immune. Nobody ever suggested that if somebody went out and assassinated somebody on the president's order, that person would be immune from prosecution.
Mr. Fox, why do we even have to go there? I mean, does the Trump case say anything about whether a government official, regardless of whether the president has immunity, regardless of whether the subordinate official has criminal immunity? Does it say anything about them being immune from being disciplined for violations of rules of a court that they have voluntarily agreed to?
Absolutely. I mean, I can't agree with you more. I would say to you in that regard, not only the fact that the Supreme Court has disciplined the president of the United States, Bill Clinton, but in the case of Imbler versus Patchman, which is Justice Powell's opinion that said that prosecutors were immune from civil actions because of official acts that they had taken. It was a wrongful prosecution, civil lawsuit. One of the reasons that he cited, and as he said, it doesn't mean that we're powerless to deter prosecutors from misconduct, is because prosecutors can be subject to professional discipline, which I think is exactly your point. So even if you got to the point where you said the aides were immune, they would still be subject to professional discipline. And to one last point on the Trump case, and that's the use of the evidence in, there's a claim not only that they're immune, but that you can't use any evidence of the president's official acts to prosecute them, or in our case, to bring a disciplinary charges. The Trump case cited the United States v. Nixon. It relied on the United States v. Nixon, which holds just the opposite. The United States v. Nixon is the Watergate tapes case. That's the case in which the Supreme Court said that the need for in the criminal justice system for the White House tapes overrode the privilege that those tapes had, the executive privilege those tapes had, in order that they be produced to Judge Sirica for in-court, in-camera examination. And then, of course, they were subsequently used to prosecute the aides. So it certainly does not apply to those that evidence that came out of that Oval Office meeting. So the final thing that I want to touch on is sanction. Even if you don't find intentional dishonesty, and even if you don't find that it was an attempt to conduct prejudicial administration of justice, the sanction for this case needs to be disbarment. Mr. Clark is utterly unrepentant. He's thrown up every crazy argument that he could find. Even the district court labeled one of his arguments, and I've forgotten the majority they use right now, but absurd. I'm sorry, absurd. You can't distinguish this case from the Eastman case or the Giuliani case, which were disbarment cases, as the hearing committee did, on the ground that in those cases the lawyers were attempting to disenfranchise large swaths of voters, because that's exactly what Mr. Clark was trying to do. The people in Georgia and probably these other states had selected and voted for Joe Biden. And he was trying to discount that, submit both sets of electors. Ultimately, that would.
Mr. Fox, couldn't we just look at this as a case about if we adopt the material aspects of the hearing committee's findings? Couldn't we simply look at this as a case about a lawyer who attempted to advance and submit with the approval of the Department of Justice a letter that contained information that we could decide was he intentionally false or recklessly false? Couldn't we find the same, sustain the findings of the hearing committee without considering the context of an election or disenfranchisement of voters? And I'll ask you this: if we took that approach, would you still be arguing for disbarment rather than the sanction that the hearing committee imposed?
The reason I can't answer your last question is because you have to look at the context. If this were, I can't think of a hypothetical.
I can think of one.
Okay.
Okay, so let's go back to the bad old days of when there were crack wars, or we could even go now and the OxyContin painkiller epidemic. Let's say there was an attorney who was an AAG in Environmental and Natural Resources Division. There had been on the internet and all kinds of public places claims that Kingpin X or Corporation ABC was responsible for nationwide drug peddling of these illegal drugs or nationwide prescriptions of known addictive medicines. And the DOJ did a bunch of investigations throughout the country, similar to these election investigations that were done. And they found that, there's pockets here, there's a transaction here, but really we can't blame this one kingpin, we can't blame this one company for being the tipping point of this drug epidemic. But this AAG in a section that didn't have to do with drug enforcement still wanted to issue this letter. We have found that Corporation ABC was responsible for this nationwide drug epidemic. And he or she wanted to rely on things in the internet and unsubstantiated, broad allegations by unnamed bail bondsmen. Couldn't we look at it that way and say, take it away from the context of an election, take it away from the context, and let's even make it so that the president, whichever president, and some anonymous president in the future, really wanted Corporation ABC to be responsible for this nationwide epidemic. Couldn't we make the same findings? And then would you still be arguing for disbarment?
The sanction for cases for conduct involving dishonesty runs the gamut. They go from censures to, I'm not sure there's any informal admonitions for them. They go from censures, I think, to disbarment. And the reason that, and so that's why context is so important. And I mean, the answer to your question is, I don't really know that it's probably, it wouldn't be disbarment under those circumstances. But I think it would be really, really wrong not to consider the context in which this conduct occurred. First of all, because other lawyers need to be deterred from engaging in this conduct. But secondly, because this was a fundamental threat to the democratic system that we have. Our system doesn't work unless the people that lose elections acquiesce in that fact and permit the majority, the winners to govern. Lincoln said, and I quoted it several times, in his first inaugural, when the South was starting to secede, that if that doesn't happen, government must cease. This was the first time since the Civil War. The hearing committee said I was greatly exaggerating when I said this, but actually President Biden said something very similar in a letter that he wrote to the January 6th committee waiving executive privilege, which is quoted in the Trump v. Thompson case. Only time since the Civil War where we've had something like this happen. And I submit that that's a great threat. And the disciplinary system needs to send a message that this cannot be tolerated. It particularly cannot be tolerated by lawyers who take an oath to support the Constitution. You can't use your law license to undermine the basic Constitution of the United States and our democratic system. And the only way to do that is to recommend disbarment.
Excuse me. So if you felt strongly about this position, that he was trying to subvert the Constitution and to not have peaceful transfer of power, then why you didn't charge him with that? You could have charged him, with under 84B that provides that it is misconduct for a lawyer to commit a criminal act that reflects adversely on his honesty, trustworthiness, or fitness as a lawyer. But in this case, really limited in scope. But we're examining whether or not he attempted to make a false statement. You didn't charge him with anything else.
Well, I don't think it would have fit under 8.4B. We did try to charge it under 8.4D, and I haven't talked about that much.
Well, then the other conduct you're talking about is
I'm sorry?
So the other conduct that you're talking about, violating the Constitution, that wasn't a charge.
It was not charged as a separate violation.
So
that's true. Because you have to consider the context in which this conduct occurred. You have to consider that lawyers have this obligation. They take an oath to support the Constitution. It's right in the oath that all of us take who are members of the DC bar. You have to consider the context in judging. I mean, the first thing that you look at when you're determining what the sanction should be is the severity of the misconduct. And the severity of this misconduct, violating oath to support the Constitution, undermining the basis of the democratic system, the severity of this conduct justifies, requires disbarment.
Counsel, the hearing committee took these back on a rhetorical authority in which you said that this is the worst since the Civil War and so on. So I have two questions. First, how do you respond to the hearing committee's concerns? And second, if you all were gonna make the contention, as you do again today, that this is dishonorable conduct, wasn't Mr. Clark entitled under such cases as Henry Buffalo to clear notice that that was what he was going to face, and that he better be prepared to meet those arguments? And without that, wasn't your argument improper going to get on the record?
I will be very surprised if my friend does not concede to you that I told them early on in the situation, long before this case went to hearing, that we were going to seek disbarment. And so I don't think there's any notice issue here. More importantly, I defend, and just tried to defend a moment ago, those statements. I do think it was the worst. And as I said, President Biden's letter to the January 6th committee, now it's focused more on the events of January 6th, but it says it's that was the most serious threat to the stability of government. I'm paraphrasing here. Since the Civil War, he used that. He used that phrase. The letter is not in evidence before the hearing committee, no. But I don't think this is a matter of evidence. I mean, it's quoted in that case, which is, I think it's cited in some of the briefs. Trump v. Thompson is the case, the DC Circuit case. But I mean, we don't exist in a vacuum.
Mr. Fox, following up on Ms. Rice Hicks's question to you, then, if it is this extraordinary and rare and such a threat, your office's only charge could be what you proffered in your initial pleadings against Mr. Clark. There's no other rule violations that fit behavior that you claim is of this magnitude?
I don't believe there are. I certainly thought about it. And as I said, Ms. Cassidy, the conduct involving dishonesty, the gamut of sanctions is wide. And it really depends on the context and the severity of it. But, you know, the severity of this misconduct, you know, I mean, and actually to come back a little bit to what Mr. Tigers was asking a moment ago, and still trying to respond to you as well. We didn't put that letter into evidence. I don't think it would have, I'm not sure it would have been relevant, but we certainly had testimony about the arguments that Mr. Clark confronted and still insisted on sending this letter that showed the severity of it. One witness, the deputy White House counsel, and incidentally, all these people, they're not partisans, they're all Trump administration appointees. The deputy White House counsel told him there would be riots in the streets, which his answer was, that's what the Insurrection Act is. At the meeting in the White House Oval Office on January 3, I think it was, in this case, it was the White House counsel said, this is a murder-suicide pact. Every single lawyer in that meeting, other than Mr. Clark, said they would resign if this letter were sent and Mr. Clark were appointed. Every assistant attorney general, except one they couldn't locate, said they would resign if this letter was sent. And it was also represented that probably most of the U.S. attorneys around the country would resign if this letter was sent. So there certainly is evidence in the record that Mr. Clark was put on notice of the consequences, the severity of the consequences of what would happen if he had been successful.
And again, Mr. Fox, you addressed this, I believe. Your point here on disbarment depends on our determining that this was intentional or no?
No. I mean, I think it was, and I think you should find that it was. But even if you don't, the first element of a sanction is the severity of the misconduct. This misconduct justifies disbarment. Unless there are any other questions.
Mr. Fox, before you sit down, I just want to make sure none of the other members of the board have questions for you. Mr. Walker, do you have any additional questions?
I do not.
Ms. Cassidy?
I do not.
Ms. Blumenthal, do you have any questions?
No, thank you.
Mr. Gilbertson?
Yes, thank you. Mr. Fox. I know this is a difficult matter, and one of the first issues in it is the one that I'm struggling with most, which is when does a bad idea ripen into an attempt to violate the ethics rules? And I understand there's not a lot of precedent on that issue, in this vein, in this disciplinary vein. So I'm concerned about the precedent that's going to be established by this case.
Well,
And just to my point, a lot of us, we're lawyers, we've got a duty to be zealous. And I know that, in a lot of in-house legal departments, bad ideas get bandied about. And they're decided against. And so you have been promoting this totality of the circumstances approach and resisting, the invitation to identify a point in time. You don't like January 3rd, but a point in time when Mr. Clark's issues, his ideas, his efforts ripened into an attempt to violate the rules. And so is there something more concrete that you can offer up as a rule that a standard that we can hold his conduct up against?
Well, if you go to the criminal law, completely inchoate attempt. I decide I want to go rob the bank, but I don't do anything about it.
Something beyond mere preparation.
Right. Yeah, you've got to do more than that. And I said from the outset of the hearing that if the December 28th letter had been offered and rejected, nothing would have happened. We wouldn't have known about it, for one thing, and nothing would have happened. But I am resisting trying to pinpoint a particular point in time because I do think the continuum of events. But I would say it certainly by January 3, by the end of the day of January 3, it had more than ripened into an attempt. And I think probably before that, I would say that when Mr. Clark starts, I would say threatening, the hearing committee says promising. I don't want to get into whether it's carrot or stick, but that these two men can save their jobs if they will send a letter which they have told him is inaccurate and that they would never send. I would certainly say at that point, but lawyers do this all the time, and we're all guilty. So I don't mean to pick on you, but we always say, well, we slice the bologna and we say, well, would it have been at this point or that point and so forth?
We turn bologna into prime ribs.
Right, right, okay. But in any event, I don't know that it's necessary to do that. I certainly think that when he sends this letter, he drafts this letter before he's ever talked to any of these people. Okay, before he's asked when he drafts the letter, he says, I want to go talk to the director of national
Intelligence. Preparation.
He hasn't done that. So he put that. He's told by the people that know. And at this point, when he writes the letter, the attorney general has already said on 2 occasions, there's no evidence of fraud that would have affected the outcome. Mr. Clark's not involved whatsoever in those investigations. He's not a prosecutor. He writes this letter. He confronts the people who do know, particularly Mr. Donahue. He says there's nothing there. That's not true. It's a false statement. It tells him right from the start it's false. He then starts insinuating that, maybe there needs to be new leadership. He then comes back and says the president's prepared to appoint me, but I'm not going to accept the appointment if you guys will send the letter. I certainly think at that point we're at a 10.
He took the protocol to have that communication with the president, is that?
I'm sorry?
There was a point where he jumped protocol to have that communication with the president.
Oh, yeah. Oh, yes.
Also an overt act. Would you identify that as an overt act?
Not
as analysis.
I see it kind of No, I wouldn't use the phrase overt act as much as I would say,
Well, that's the case's term. I'm trying to find an overt act because the criminal law on attempt requires one.
well, the overt act, I mean, certainly when you get to the point where he's saying, I'm going to accept the offer of being acting attorney general so I can send this letter unless you guys will do it. Then I think you've got your overt act. And then if that's not an overt act, the next day he comes back and say, okay, I have accepted the offer. I'm going to be acting attorney general. Surely there's an overt act at that point.
Mr. Fox, following up on your, overt acts and, the context in trying to determine a sanction here. If we turn to criminal law, if using the bank robber driving away, if they drive over somebody as they flee from that scene, they'll be held culpable for driving over that person. However, if the head sheriff goes home that night, exhausted from a long day of trying to solve, a bank robbery, accidentally knocks a candle over, lights his home on fire and the whole neighborhood in flames, right? How can you then go back and blame that on the robber? Because it seems to me that you don't seem to end the ramifications of Mr. Clark's behavior or choices. It seems that you're asking this committee to look at a context that's far broader because his fellow lawyers ultimately prevail upon this letter not going out. So it seems like it ends there. To continue and extrapolate further into situations of January 6th or civil wars or something of that nature seems almost to be a bridge too far, even considering the context of this letter in light of my analogy.
Let me make a couple of points.
Yes.
First, if you read about the indictment in Florida, I think it came down yesterday of the fellow who tried to assassinate President Trump down there. I think they applied the tipping over the candle analogy, but I agree with you that that would not be appropriate to charge felony murder or whatever it is. But I don't think that's and I did not mean to suggest that Mr. Clark could have foreseen the events of January 6th. I didn't mean to suggest that. But what I do think is clear that any lawyer is that challenging without any basis in fact the results of a presidential election is a serious interference with the constitutional structure of this country. And I think that is utterly foreseeable. It's not anything foreseeable. I think it's what he was trying to do. That was the end goal. And for that, I believe he should be held responsible.
Okay. Ms. Rice Hicks, do you have any additional questions? Mr. Tiger, do you have any additional questions?
Oh, no question. Thank you.
Ms. Spiegel, do you have any questions?
Yeah.
Thank you. Oh, Mr. Fox, I'm going to give you 5 minutes for rebuttal. You use up your time plus, but.
Thank you. May it please the board, Charles Burnham, on behalf of Jeffrey Clark. Members of the board, it was just in July of this year that the Supreme Court in Trump versus United States was at pains to emphasize the need our country has for an energetic executive whose powers remain unchilled by the threat of serious legal liability. It was only 1 month later that Hearing Committee 12 issued its report and recommendation, calling for the potentially indefinite suspension of the former acting Attorney General of the United States. The Hearing Committee's recommendation was based on an illegally leaked and unenacted policy proposal, which disciplinary counsel's own witnesses testified, and the Hearing Committee specifically found was offered in good faith, at great personal cost, and pursuant to a remarkable act of personal bravery. This is the first case of its type for any bar association anywhere in the country, and it will set an important precedent going forward that will apply to every future government lawyer. And really, the important part about this case is we know there will come a day when some future government lawyer feels compelled to take a risky stand at personal risk on principle. Think of some of the episodes in our history, warrantless wiretapping, torture, or other examples. There's going to come a day where that anonymous lawyer has to take that stand. And the decision.
Mr. Burnham, I think you're making really good, important points that we definitely have to look at. But in this situation, what you have is a government attorney making an argument for something. Always a valuable thing, always valuable to have government attorneys who are willing to take a position opposite to their supervisors. But then the supervisor says, you know, what you're saying is just not accurate. We have looked into this and there's just nothing there to support what you're saying. And here's what we'll do. You have access to all the files. We'll even take steps where we'll give you access to things that are otherwise restricted beyond your already authorized clearance level. And here's the personal cell phone number of the U.S. Attorney in Atlanta who did, a lot of this work. Talk to that person and educate yourself on these things. We're giving you all respect for you and your viewpoint. We're giving you access to all of this. Please look at this and then come back and you'll see what we're saying. It's not a matter of opinion. It's a matter of fact. So that takes this situation away from the situation that you're describing, doesn't it?
I don't believe it does, Madam Chairwoman, and respectfully, I would take issue with part of the factual predicates that the Chairwoman laid out, and particularly a couple of particularly relevant pieces of testimony from Mr. Donahue in particular. Recall that the proof of concept letter, the main source that it cited was the report of Senator Layton of the Georgia legislature. And Mr. Donahue testified specifically as to that report. He said he didn't read the report. He read part of it, didn't read the whole thing. He never said that the witnesses upon whose testimony the report was based were lying, or that their credibility had been undermined in some significant way. His response was that those matters were not issues that the Department of Justice would get involved in. Under his view, the Department of Justice, he's a former prosecutor, the Department of Justice had a duty to investigate criminal violations of the federal criminal law. And he called them irregularities or process issues insofar as they suggested violations of the criminal law or perhaps a civil rights lawsuit. So he did not say that that Mr. Clark's factual predicate insofar as it's known within the constraints of the Fifth Amendment was inaccurate. Not at all. And in fact, the chairman or the hearing committee specifically found that the election in Georgia, in fact, was not conducted pursuant to state law. And this actually I hope that answers the chairwoman's question.
So no, you're saying in other words that Donahue was saying the Department of Justice does a different type of investigation. And our inquiry ends when we see that there's not an effect that would have changed the outcome of
That's exactly that.
And so where in the record does it say that what Mr. Clark was actually arguing for was an expansion of the Department of Justice's review?
It's not phrased in exactly that way, but the record does make a comparable point where the hearing committee finds, based on a number of sources, including the testimony of former Attorney General Meese, that the Department of Justice's ability to give advice is unlimited. And when I say unlimited, I mean unlimited both in terms of the subject matter of the advice and the persons to whom the advice is delivered. The Department of Justice advises foreign countries, state governments, state law enforcement, and perhaps in certain cases, state legislatures as well. Recall that Mr. Clark was not proposing a draft complaint to be filed or a draft criminal indictment to be presented to a grand jury. He was simply proposing a letter expressing pursuant to what I call the advice function of the Department of Justice. The Department of Justice litigates and it gives advice. Mr. Clark was proposing advice on constitutional issues that the Department of Justice could deliver to, in this case, the Georgia State Legislature.
But Mr. Burnham, isn't there a difference between advice and facts? Advice is from a lawyer. It is my opinion that you can interpret the United States Constitution, Fourth Amendment as follows. That's an opinion. It could also be advice because given my opinion, I advise that you can execute the search warrant. Is that not different from your word was a good faith, good faith behavior by a government lawyer, making statements of facts and making factual representations? So we're not talking about advice and opinion. We're talking about factual representations. And my question to you is a government lawyer or any lawyer allowed to make a factual representation when that fact is not supported by actual evidence?
No, a government lawyer, any lawyer can't make knowing misrepresentations, but we absolutely dispute that Mr. Clark made such representations either knowingly or recklessly. And really, there's 3 alleged misrepresentations in the record here that go directly, Ms. Cassidy, I think, to the question that was just posed. The 3 alleged misrepresentations that the committee found are as follows: that there were significant concerns, that's the first. Second has to do with the second slate of electors. And the third one has to do with the way that the Ligon report was presented and whether that was misleading. I can address all of them. I welcome any further questions, but I'll start with the first one. The exact language, I think I can quote it from memory of I'll call it the first alleged misrepresentation, was that the Department of Justice has identified significant concerns that may, emphasis on may, have impacted the results of the election in Georgia. And I'll pause to note what that sentence is not saying. It's not saying there was criminal fraud. It's not saying the evidence was conclusive. It's not even saying the evidence was outcome determinative. And that statement in the letter itself was based on the testimony in the Ligon report, something like 10 witnesses that all testified.
May I interrupt and ask, what was your client's basis at that time for making any evaluation about whether activity or alleged activity in Georgia might have impacted the election? Was he an election attorney? Did he work in the election law section of the Department of Justice? Had he previously been involved in election type issues? Did he have any professional experience based upon which he could make an evaluation of what was and was not a significant concern about the electoral process in the state?
He absolutely does, Mr. Walker. And I'll pause to just note that the entirety of his basis is not known because of our Fifth Amendment problems. And I absolutely welcome questions about that, but I'll skip over that for a moment and answer the questions directly. To the extent it's revealed in the record, the basis for Mr. Clark's authorship of the letter is the Ligon report, which is extremely detailed and endorsed by several members of the legislature. It came into the record that he was reviewing the civil filings, including affidavits of litigation related to the elections. That's open source.
But I guess I'm asking, prior to this, prior to his getting involved with these issues in this election, did he have any experience in evaluating the nature and weight of evidence in electoral matters?
There's nothing in the record about that. He's primarily an environmental and administrative lawyer, but the rules are clear that a lawyer is not prohibited from taking on a matter outside of his area of expertise if he puts in the time necessary to study it, which the record shows that he did. Not to mention, Mr. Clark was operating specifically at the direction of the president, saying, can you please help me ensure the laws are faithfully executed by doing this, right? And so absolutely,
Council, if I may interrupt, as to that point, you said that he's acting on behalf of the president. The letter I thought was drafted to Rosen and Donovan. So in that capacity, was he acting for the president then?
There was the testimony, or the evidence was that there was a meeting between Mr. Clark and the president prior to the composition of the letter. It wasn't entered into the record for privilege and other reasons, exactly what the content of that meeting was. But two important things happened after that made it clear that Mr. Clark was operating through a direct grant of authority from the president. One is Mr. Rosen, who was the acting attorney general at the time, ordered the intelligence briefing because Mr. Clark specifically was operating at the direction of the president. He wouldn't ordinarily possibly have gotten such a briefing, but Mr. Rosen authorized it for that reason. Also in the record is two emails from Chief of Staff, former Congressman Mark Meadows, to Mr. Rosen from the president, asking Mr. Clark specifically to look into election-related matters. And then, of course, later on, Mr. Clark was actually appointed acting attorney general by the president himself. So this is
Was it Mr. Donahue? Did he have information that your client did not have, such as the other intelligence briefings and investigations? So he would not have the basis of knowledge to know everything that was included in all the investigations to make those statements in the concept letters.
Mr. Donahue did certainly have at least some information Mr. Clark didn't have, but I'd make 2 points. One is Mr. Donahue was highly equivocal as to whether Mr. Clark asked for that and whether he made it available. We didn't really get a straight answer about that. But more importantly, Mr. Donahue was clear. One thing he was clear upon is that he was not going to investigate anything involving the election unless it led directly to a criminal indictment, as I said before, or a civil rights lawsuit. So Mr. Donahue had effectively told Mr. Clark, this stuff you're looking into, you're investigating, the stuff the president wants you to look into, I'm not dealing with that.
And why was that? In the record, yes, Mr. Donahue explains why he was not, DOJ is not going to do that because that was not in the purview to investigate. He made clear to your client that DOJ does not get involved in those types of activities.
He does, but he doesn't cite any constitutional provision or law restricting DOJ from investigating those matters. Again, filing a lawsuit or bringing a criminal indictment, different story. But in terms of simply investigating and giving advice, that was Mr. Donahue's opinion. Maybe he's had good reasons for it. Mr. Clark was free to disagree with it. And the hearing committee specifically found that there are no limitations on who in the DOJ can give advice to and the subject matter of those advice. And that's really gets to, I'm sorry, I didn't interrupt.
No, you finish your point. No.
That really gets to why this case is so important and that it inevitably bleeds into, even with the best of intentions, kind of second guessing of what are fundamentally policy decisions by high government officials, not intended to be subject to the rules of professional discipline. And Mr. Donahue's views of the role of the Department of Justice are a great example of that. He had those views, probably had good reasons for it, but they weren't based in the law. And it wasn't a per se disciplinary infraction for the president or for Mr. Clark to take a different view. And the hearing committee is very much on our side. Sorry, I think I interrupted.
The question I have for you, the way the record of this case reads is not a situation involving a debate over the scope of what Department of Justice should investigate in terms of election irregularities. So the Department of Justice has, as articulated by Mr. Donahue, they prosecute criminal violations or civil rights violations tied to election issues. So there's no reason for them to investigate beyond that. Now you're saying that I didn't see anything that would support this interpretation, but you're saying that what respondent was actually arguing for was an expansion of the investigative scope to include irregularities that Department of Justice viewed as within the purview of state election authorities. But I don't see that happening. What I see happening is that respondent wrote a letter that was intended to be sent to the Georgia state legislature, correct?
Sure.
And that he had representations and wording in the letter that people with more knowledge told him were false. It wasn't a debate about scope of investigation, was it?
Well, I continue to insist very respectfully that nobody told him that particular allegations on which the letter was based were false. Mr. Donahue testified specifically on that point where he said, I read part of the Ligon report, but not the whole thing. And that's just not the kind of thing we get into. He didn't say this allegation is false, that's false, that's false. He said categorically, we shouldn't touch that. And maybe Your Honor's question is in part, or Madam Chairwoman's question is in part reflecting that view that the Department of Justice sort of simply shouldn't have gone there. In fact, one of our own witnesses, we're not afraid of the contrary view. Our witness, Professor Elliott, said there was nothing legally or ethically inappropriate about the letter, but if it was him, he wouldn't send it. It was a good idea, which is perfectly defensible. When you take the view as to was there a legal reason why the letter was inappropriate or misconduct. There absolutely was not, right? It's undisputed. Mr. Fox hasn't disputed this, that there's no limitations on the DOJ's advice function. And what Mr. Clark was really doing was doing the necessary factual investigation, as he would do perhaps if there was a Fourth Amendment question.
Doesn't the language of the letter go beyond the mere advisory to the urging and even beyond recommending? You know, it says, given the urgency of this serious matter, the department believes that a special session of the Georgia General Assembly is warranted and is in the national interest. In light of these developments, the department recommends that the Georgia General Assembly should convene in special session so that its legislators are in a position to take additional testimony. Doesn't the letter go beyond the merely advisory to, recommending specific concrete steps? Just the way it's phrased, it's an urging letter more than an advising letter, isn't it?
Well, it does use the term recommend as was recited many times, and the federal government has different ways of getting people to do things, withholding federal funding or something. There's nothing like that. And I think most importantly, not only is it just recommendations, but it doesn't even make a recommendation as to the particular outcome of the legislative session should one have taken place. It doesn't say we think the legislature should select the Republican electors. It doesn't say anything like that. It simply says, we think, Mr. Georgia legislators, you have this authority. We recommend that you should use it, but in terms of the outcome, that's up to you all. And it's entirely possible.
But it ends with this statement. Therefore, whether called into session by the governor or by its own inherent authority, the Department of Justice urges the Georgia General Assembly to convene in special session to address this pressing matter of overriding national importance. Don't you think that goes beyond the advisory, and if it's a word, the recommendatory?
No, respectfully, I don't, Your Honor. It's entirely appropriate when giving advice to emphasize the reasons why the advice is important. It should be listened to. I mean, the issue there was that, recall that I want to answer the question directly, but an important predicate is that the hearing committee found no misconduct or legal problem with what I'll call the underlying legal theory of the letter, which is the independent state legislature doctrine as it existed at that time. There was absolutely nothing inappropriate with arguing, I'll summarize it quickly, that the legislature has the authority to select electors. It can delegate it to the voters and often does. It has the ability to reclaim that authority at any time. That comes from the McPherson case. It shouldn't do so arbitrarily, but if there's evidence of serious violations of the constitutional time, place, and manner of the election, it's appropriate potentially for the legislature to address that. And it's all Mr. Clark was arguing for.
But Mr. Burnham, if I may jump in here to follow up on my colleague, your letter says, we have identified significant concerns. That's your December 28th letter. Your January 3rd letter says, as of today, there's evidence of significant irregularities. And we could go through this letter word by word and interpret what they may mean. But what do you do with the evidence that the White House lawyers, the other lawyers at the Department of Justice, including other high-ranking lawyers, were of the opinion that these facts were inaccurate? This letter was factually inaccurate, not a policy position, not an argument for something interpreting the law, but were factually inaccurate. And they were not going to stand by and maintain their jobs if this letter, factually inaccurate, was sent to Georgia. How do you address that testimony from Rosen, testimony from Donahue, and in the choices that those other lawyers were prepared to make because of the fact that this letter was factually inaccurate from their perspectives?
Well, first, I continue to insist respectfully that neither one specifically said these allegations on which the letter are based are false. They said that's not within our purview, which we think is wrong. But I'll take to answer your Honor's question, I'll pose my own hypothetical. Let's imagine that they did say your facts are false. It's not an ethical violation, of course, to disagree about factual matters. Mr. Rosen could have said, I think the facts are X. Mr. Clark would say, no.
Let me stop you there then. Why didn't Mr. Rosen then proffer forward facts? Why did not Mr. Rosen meet with the United States Attorney in Georgia?
Clark.
I'm sorry, Mr. Clark meet with the United States Attorney in Georgia?
Well, this is again, weren't really able to explain that very well, because as Mr. Tiger pointed out, we're in a little bit of a different situation, but I think the board can make a very easy, reasonable inference about the probable reason. And again, the reason being is it's in the record, this is a factual finding that the policy of the Department of Justice, as implemented in particular by Mr. Donahue, was that in the absence of evidence of a prosecutable criminal violation, the department wasn't going to go there, and that would easily have applied to Mr. Pack as well. And there's some sort of the background of that is I think, and this Professor Elliott gets to this as well, is one of the dangers in government is that groupthink can take hold, right, and impede decision making. And I think it's a reasonable inference that President Trump saw that there might be groupthink here. Everybody agreed. So let me go to this one guy here that's a little bit of an outside the box thinker, maybe a little bit rubs people the wrong way, and let me see what he thinks. And so it was only natural that Mr. Clark, given the time frame, wasn't going to listen to the groupthink 2, 3, 4, 5, 6 times. He already heard that from Mr. Donahue and Mr. Rosen. His task was to look at the things that other people weren't looking at. And that's, I think, even though we don't really know from the record exactly why Mr. Clark didn't call Mr. Pack, I think that's a very reasonable inference. I'll also correct one thing, to the extent that's relevant, my brother counsel said it wasn't really a directive to call Mr. Pack. It wasn't, I ordered you to call Mr. Pack. It was, here's his cell phone. I think that's all the email said.
Yeah, but Mr. Burnham, Mr. Respondent was being given the respect of his superiors, listening to his viewpoint, and very, in a show of quite a good deal of respect for him, offering him all these resources to look at. And I think you're making a good argument, and an argument that needs to be made. But one thing I wanted to ask you, moving away a little bit from the letter and those things, is it's really striking that at a certain point, Respondent basically said to his superiors at the Department of Justice, the president's going to give me your job. I have until Monday to tell him whether I want your job, but you can avoid that fate by doing what I want, which is to send this letter to the Georgia State Legislature, not explaining to them the scope of what DOJ was investigating, but adopting my view of what the concerns are. I mean, what are we supposed to do with that?
Certainly, that's a great question. And I think the hearing committee actually handled that very carefully. The hearing committee did not find that it was a threat, because there's sort of 2 interpretations you could place on that. And I think the correct interpretation has to be considered in light of the testimony, very important testimony to which Mr. Fox referred from Mr. Philbin, you recall was the deputy White House counsel. Mr. Philbin and Mr. Clark went back a long ways. They were friends. Mr. Philbin calls Mr. Clark when all this was going on and says, Mr. Clark, we go back a long ways. What are you doing here? Chances of success are so small, and you're throwing away your career, and for what? And this testimony was credited. And Mr. Clark's response is, I know you're right, but I feel like for whatever reason, this has landed on my door. I'm paraphrasing, but I can't live with myself if I'm the only one that's willing to look at this and I just let it pass me by. I think that the board can reasonably infer from that Mr. Clark would have been overjoyed had Mr. Donahue and Mr. Rosen agreed to stay on and work with him on what he thought was his duty to pursue. This is not some Machiavellian scheme he had to become the acting attorney general for 2 years. He knew the risks he was taking. And in fact, he suffered all those risks Mr. Philbin posed to him and more. So I take the absolute opposite interpretation of that conversation, which is very important from what Mr. Fox is taking.
Counsel, you rely in part on 28 United States Code Section 511.
Yes.
Which says that the Attorney General shall give, quote, advice and opinions to the President, right?
Yes.
Now, isn't it reasonable to read that statute as saying that the advice and opinion should be given fully in compliance with all of the rules of professional responsibility in any jurisdiction where the Attorney General is admitted? Isn't that the way that we read that?
I don't say I would disagree with it. There are certain privileges that might come into play when evaluating that, but as a general matter, I wouldn't disagree with that, no.
That's what it says, that's the thing. Now, the second thing is, hasn't the Supreme Court of the United States said on at least 3 occasions? That I know, I mean, 1812, 1822, 1991, that every court of justice in the United States has the inherent power to regulate the conduct and to discipline the lawyers who are admitted to fraud. Would you agree with that?
I do agree with that.
Well, then, why can't we do this case?
Well, first, because there were no,
Lawyers are lawyers for the president.
I'm sorry, I didn't get the end of.
If your answer is, well, it's because these are lawyers advising the president, then I would ask you to look back at what Chief Justice Marshall said in Marbury versus Madison about the difference in accountability between the president and ex-president and those subordinate officers, such as that guy James Madison, who wouldn't give Judge Marbury his commission. So I know it's complicated, but I'd like to hear you.
Certainly, Mr. Tiger, I'll respond to that. And really, what I think the crucial observation there is, and basically, Your Honor's question gets the interpretation of Trump versus United States, as I take it, and whether it extends to subordinate officers. Is that what the question is driving at?
Well, but it starts with what even with justices with whom you might disagree in Trump, I mean, well, everybody agrees you gotta read the statute.
Yes.
Right, and the statute said, I mean, Connecticut National Bank versus St. Germain, Justice Thomas said, read the statute first, then talk to us. So let's read that statute, which you have just conceded, I think, has to require that the lawyer act in accordance with the rules of professional responsibility.
I understand. Two
And
responses.
so, I mean, for example, if I were to take on somebody who says, I tell you what, pay you $1,000 an hour for your advice and opinion. But by the way, if you screw it up, there's no consequence. That's never happened to me.
Two responses. The first is obviously we contend that there were no ethical violations here at all, which resolves all the questions posed by the question.
Yeah.
But secondly, the statute that Councilmember Tiger relied on does apply, as does 18 United States 1512, the obstruction of official proceeding statute.
Yes.
Which the Supreme Court found could not apply to the president in Trump versus United States under immunity. So the constitutional doctrines on presidential immunity can supersede even duly passed statutes if it relates to the president's exclusive and preclusive authority. If it doesn't, maybe it's a different question. And here in Trump versus United States, literally these same facts were the first example of the president's exclusive and preclusive authority. Mr. Clark's very conduct alleged here. So the question of whether it could apply to him too, I submit should be analyzed as follows. The Trump versus United States decision goes on for page after page about the need for an energetic executive, candor from advisors. It says that several times. Quick decision making under exigent circumstances. And of course, the Supreme Court didn't go beyond Mr. Trump because that was the only question that was posed.
Yeah, but Mr. Burnham, are you saying that we should independently apply these considerations that were discussed in Trump v. United States to find that the rules of professional conduct shouldn't apply to lawyers who work for the president?
I'll specifically state as concisely as I can the rule that I'm proposing in response to Madam Chairwoman's question. We're proposing that Trump versus United States applies at a minimum to individuals who are given direct instructions from the president to help him execute the laws in situations involving the president's exclusive and preclusive authority. There may be some delicate line drawing exercises that other courts and tribunals may have to engage in to see how far it goes beyond that. But that's, we think, is the most conservative, limited interpretation of Trump versus United States that's appropriate here. And the reason why we say that is I can illustrate it by posing this question. Is what good is presidential immunity at all in achieving energetic, decisive executive government if the president has literally no one to help him carry out his decisions that aren't chilled by threats of legal liability. Let's just look at the facts of this case. The president was concerned about unconstitutional actions in Georgia. He wasn't going to get on a plane himself and go down there and interview witnesses, or not being a lawyer, sign up for Westlaw and start reading the cases. For presidential immunity to be worth anything at all, for all the controversy it's generated, it has to apply to at least some zone of the president's inner advisors. And secondly, and I want to answer Councilmember Tiger's question about, is bar discipline different?
Wouldn't the framers be more comfortable if the immune president, at the very least, was required to have advisors, who nominated, who would give him or her advice, because that turns out to be the only safeguard against unlawful conduct for the president himself or herself.
I'm not sure the framers would have concluded that respectfully, because
Mr. Burnham, I don't think, I can't get into the minds of, the personal minds of the decision makers in Trump v. United States. But I would imagine that none of them went with relish to the idea that they would potentially be giving future presidents carte blanche to commit illegal conduct. I don't think that's what any of them wanted. It was a weighing, the risk that the country would be endangered if the executive branch was crippled by the potential for criminal prosecution for decisions made, official acts, decisions made as part of official acts. So this whole concept of a zone of advisors, first of all, I'm glad you just put it out there that that's what you're asking for, so we can consider it that way. But when the Trump v. US case came down, and when it was being anticipated, everybody was talking about the hypothetical of the president ordering SEAL Team 6 to kill a political rival. And the response to that is SEAL Team 6 would be prosecuted for murder if that happened. And then the surrebuttal would be, but then the president would pardon all of them, right? Isn't that how it goes? So
I agree, that's how it goes.
And that's the weighing and the balancing that has to be done. But I'm glad you just put it out there that that's what you were asking. Because but even then, I'm sorry to cut you off, but even then, we're not even talking here about criminal prosecution or civil. We're talking about basically the oversight of a bar license, a license to practice law. And in all of our lifetime, almost all, there's young people in here, almost all of our lifetimes in this room, we've had a president surrender his bar license after leaving office because of lying in a proceeding that had nothing to do with his official actions.
That's right.
So if you're a president who's a member of a bar, you could leave office with a 70% approval rating and still lose your bar license.
Well, there's a couple different points in that very good question. One is that the prior cases where presidents have had disciplinary action are distinguishable. I guess Madam Chairman may be alluding to former President Trump. The basis of that was actions, I think, that were pretty clearly outside of the exclusive and conclusive authority. It was the Lewinsky matter. So that's distinguishable on that side. President Nixon is the other example you normally hear, and he just totally ignored it. I'm going to California, don't talk to me. It was a default judgment, so it's not presidential for much of anything. As to the hypothetical, SEAL Team 6 and so on, that was presented to the Supreme Court, and I think the Chief Justice's response was right. It's basically there can be horrible hypotheticals, but that shouldn't control the outcome here, because there can be horrible hypotheticals on the other side. If there's no immunity, then you have warring prosecutions of presidents every time there's a transfer of power. It's a controversial part of our Constitution, but the Supreme Court and our framers made the considered decision that the risks of having presidential immunity outweigh the dangers of it. And I think the logical extension of that is it can't be confined to the literal person of the president. And I want to address the point about, is bar discipline different? And I would submit that it's not, for this reason. The Supreme Court's analysis was very much a functional analysis. It was like, what's the effect going to be on our government? It wasn't so much about exactly what's the nature of the legal proceeding. And
the Supreme Court's case was very limited in scope. It examined the president's conduct. You're asking this board to expand the focus of federal decision, which I don't see a basis for doing that. The question here is not his advice that was given to the president. The question is whether or not his conduct in making false statements in that letter should be subject to the rules of conduct in this jurisdiction. And that's what the focus should be. So explain why his conduct should not be subject to discipline as an attorney.
His conduct should not be subject to discipline because it was within the exclusive and preclusive authority of the president, and imposing discipline under those circumstances would exert the exact chilling effect that Trump versus the United States was trying to avoid. Criminal bar cases are described by this very Court of Appeals as quasi-criminal, and the consequences and thereby the deterrent effect of bar prosecutions, quasi-criminal though they are equal to or greater than many criminal cases, where you can imagine criminal cases that are much less significant, both in terms of punishment and public opprobrium, than a proceeding like this, where Mr. Clark stands accused by a disciplinary counsel of engaging in the worst conduct since the Civil War and being thrown out of the profession.
Full counsel would be a deterrent for attorneys that are giving advice to the president not to put false statements in a letter, or when they're giving advice, that their statement should be, if they're going to make a recommendation, that they should, use their due diligence to make sure whatever information you're giving to the president is accurate.
And
Would you agree?
Absolutely, and we further would say Mr. Clark did exactly that. We absolutely maintain that he did due diligence and did not make any false statements to the president or anybody else. But here he is having to defend for the past several years his law license and at risk of being imprisoned. And sometimes the process is the punishment, and that too is one of the problems that I would submit Trump versus United States was trying to avoid. I'm not asking this board to expand what the Supreme Court did, but it does have to be applied to these facts. And that's all we're asking the court to do. Take the most narrow, cautious interpretation possible in light of the manifest purposes the Supreme Court was trying to achieve and apply them to the facts of this case.
On a little more, I understand, I hear your argument, but stepping back for a moment and assuming that we're going to consider that among other arguments made and other facts proven, I'd like you to respond to disciplinary counsel's arguments and approach to the issue of whether we should or can make a negative inference from your client's taking or asserting his Fifth Amendment rights. Can we, should we make such a negative inference?
Well, the answer is no to both, for both theoretical and intensely practical reasons. The theoretical reason is, and I'll be candid, is there's no case on point from the Court of Appeals about whether the adverse inference can be drawn, and we can look at all the other states and have to split. Some go one way, some go the other. But we would submit, for many of the same reasons about the significance of bar discipline cases I just mentioned in my prior answer, that because these cases are quasi-criminal, that has been held multiple times by our Court of Appeals, because they have such great impact on the liberty, professional rights, and property rights of the respondents. The better reason cases do hold that, as in criminal cases, an adverse inference should not be drawn. That's the theoretical reason. The practical reason is this. Respectfully, I don't think an important consideration in evaluating any Fifth Amendment assertion is really two things: waiver and the link in the chain doctrine. Any statement that could be used, it doesn't have to be itself incriminating. It could be a link in the chain leading to prosecution. That's incriminating. So in this case, Mr. Clark gets on the stand and says, "I'm Jeffrey Clark. I worked at the Department of Justice. I wrote the letter. I was in that meeting." All of those statements, though not incriminating in themselves, are incriminating in the Fifth Amendment sense, for the reason that they're all things a prosecutor would have to prove if there was ever a criminal case. That's the first thing. The second thing is, courts have been clear that defendants, as Mr. Fox, and respondents, as Mr. Fox has at times suggested, cannot get on the stand and sort of pick and choose questions on the same subject matter that they'll assert the Fifth to. That is a waiver, 100%. Mr. Clark did not have that option. If he had gone up there and started testifying and just picked a few questions, waiver, no question about it. And that is common practice in the defense bar, not to let your client do that. So I'll bring that back to the question about adverse inference. And I think this is really what Chairman Hirsch was looking at, is what exactly am I going to draw an adverse inference to? Like, how do I decide which questions? There's really no way to do it without a manifest injustice. And I think that also has to be considered in light of the fact that, whoa, boy, did he ever have a well-grounded Fifth Amendment right. He was literally a current criminal defendant, the first time ever in DC bar history, as far as I can tell, facing charges carrying life. He was an unindicted co-conspirator in a federal case, could have been superseded at any moment to be a defendant in that case. Agents raided his house, dragged him out in his underwear. I was there that day. I saw it happen. I could go on and on. I won't belabor the point. But this was about as well-grounded a Fifth Amendment assertion as this body has ever seen. We had no choice but to do it. Mr. Clark didn't like it. I didn't like it. We were forced into it. It would be a manifest injustice to assume he had no evidence. He was a liar. Whatever else the disciplinary counsel is urging this board to be. I see my time has expired. Are there further questions?
Before you sit, let me just make sure none of the other members of the board have more questions. Mr. Walker, do you have any other questions?
No, I don't. Thank you.
Ms. Cassidy?
No, I don't.
Ms. Blumenthal, do you have any questions?
No, I don't.
Mr. Gilbertson?
No, thank you.
Ms. Rice, do you have any more questions?
No.
Mr. Tiger?
No, thank you.
Ms. Spiegel?
No, thank you.
Thank you, Mr. Burns.
Thank you, Council.
Oh, and you can have your 10 minutes for rebuttal, for Sir rebuttal.
Thank you.
I really want to make one point. I said in my brief, I was trying to be ironic, that Mr. Clark's briefs were remarkably restrained in their references to the record. I think if you look at those briefs, you'll see virtually no references to the findings of fact. And I make that point because there were a number of assertions about facts that were mismade to you, which I don't believe are anywhere in the record, and they're certainly not cited anywhere in the brief. Indeed, the record is to the contrary. For example, I think, and I may be paraphrasing it, but I think Mr. Burnham said that nobody ever told Mr. Clark that his letter was factually wrong. The findings of fact are replete. There are long quotations for the testimony of finding of fact 94 and finding of fact 96 of people telling him exactly that. And Mr. Burnham's statement a moment ago about the department not investigating irregularities was a complete distortion. What the testimony was is that we don't have any authority to correct irregularities in state procedures, but if irregularities are evidence of fraud, of course we look at that. That was what the testimony was. The testimony that his representations about Chairman Lincoln's report, read what the hearing committee said about Chairman Lincoln's report. His representation that Mr. Clark did his due diligence before he drafted that letter. There's nothing in the record to support that. The only reference to due diligence is that when Mr. Clark was asked why didn't he call the U.S. attorney, he said, well, he was talking to witnesses of his own, and that was rather reference to the bail bondsman camp. So I would suggest to you that before you accept any of those factual representations, none of which were made in the brief, because the brief had virtually no assertions about the facts in this case, that you look carefully at the record. And that's really all that I have to say in rebuttal, unless there are any questions that the board has.
Yeah, please.
A couple of points I'll respond to Mr. Fox said. I wish I was the type of lawyer that could rattle off paragraphs, but the provisions I'm relying on, I can assert confidently are in there. But to Mr. Donohue's testimony, where he specifically says he read part of the Ligon report and not all of it, he decided it wasn't the type of thing the DOJ gets into. And I think really the point there is there are generalized statements in the record that I think Mr. Fox is referring to of, oh, we don't think there's anything to what Mr. Clark is saying. But the more useful statements for this board's analysis are the specific ones that get right to the claims Mr. Clark was making. And there, Mr. Donahue does not directly contradict what Mr. Clark is saying. That's one point. Secondly, just a brief follow-up to the hopefully helpful immunity discussion I had with several more board members. I just want to point out, and this is in our briefs, that there is a concept that has been developed over the years of qualified immunity, which obviously is going to be less than what the president gets. And I think there's one case here that's particularly on point there, involving former Attorney General Mitchell. I forget the other party. It was Mitchell versus somebody, where he wiretapped, did a warrantless wiretap of some kind of subversive group that was planning a bombing or something. And I guess at that point of history, there was at least some colorable argument that you could do that. You didn't need a warrant. And the Supreme Court said, okay, well, we don't think you were right. You needed a warrant, but because you're the Attorney General, it was national security, and we haven't exactly settled this question. We're going to give you qualified immunity for that decision. The way I think of it is it has to be a flagrant foul, which avoids some of the, I admit, difficult consequences that were, I think, underlying some of the questions from the
Yeah,
board.
but Mr. Burnham, that still doesn't go to the issue of a bar license.
And I'm sorry, it's your bar license. And
The qualified immunity defense
yes,
still would not get a lawyer out from under a discipline charge. If it was conduct that would give rise to a disciplinary charge.
we respectfully maintain that it is, I don't know, the board doesn't have to reach that question. But the theory, I think that Madam Chairwoman's question and others is that you have civil, which can be subject to immunity, and you have criminal, which can be subject to immunity, and then you have bar discipline, which sort of can sneak through the gap in between, which I continue to contend is completely functionally and theoretically inconsistent with all the immunity line of cases.
But Mr. Burnham, following up on this question though, that would go to legal analysis, not facts. Using the Mitchell case, which I'm not at all familiar with, is I'm sure the United States Attorney Mitchell would have been prosecuted if he made up facts. This group has a bomb, and then went off and searched them, searched their homes, searched their persons, searched their curtilage with absolutely nary a fact that that's accurate. He would have faced, I would imagine, disciplinary action for putting forth inaccurate, dishonest statements to a court. And that's what we're dealing with here. We're not dealing with an interpretation of law. We're talking about factual statements and whether or not an attorney has done adequate due diligence to assure statements that they're making to urge other parties, regardless of who that is, to rely on their advice. So can you parse that for us away from the lawyer's right to give advice and interpret laws? When it sounds like to me, again, it's my initial question, it sounds like to me you're suggesting that a lawyer is allowed to go off into the world and make factual statements without any due diligence or support for those statements. And if they do so, they may have immunity, they may have qualified immunity, or they may be just sharing their opinion, which is within the province of an attorney. I see it as different. So if you can explain to me what your argument is in that respect regarding facts, it would help this board.
Well, the easiest way to thread that needle is there were no misrepresentations in that case. If I can hopefully persuade the board to come around to a review on that, the immunity question becomes to a certain extent unnecessary. And I already spent some time on the alleged first misrepresentations. So hopefully in answer to the question, I'll hit the remaining two, which we don't believe are misrepresentations, either reckless or otherwise either. The second one, I hope, is very simple. It has to do with the electors. Mr. Clark never said 2 sets of certified electors were sent. The letter doesn't say that. It doesn't say Georgia sent 2 sets of electors. It just said there were 2 sets of electors. And this gets to the motion I filed. The whole world knows that was the case. There's a debate about exactly what the legal significance of the second set was, but everybody knows they existed. That's all the letter says. That's the second misrepresentation, which leads us to the third. And the third was where Mr. Clark says the department is investigating the matters in Chairman Ligon's report. The hearing committee manifestly did not find there was anything inaccurate in the Chairman Ligon's report, nor did Mr. Donahue or Mr. Rosen assert that there was. The only misrepresentative part of that the hearing committee found was that it misrepresented the role of the Department of, or was misleading as to the role of the Department of Justice, in the sense that the Department of Justice committee thought didn't get involved in state election laws. The answer to that question is the committee's own factual finding that the advice function is not limited to particular causes of action like civil rights or criminal prosecution. The Department of Justice absolutely can give advice to state legislatures on whatever, in this case, election law. That's why the statement was not a misrepresentation. And there's another part here to it too, that even if we can assume for purposes of argument that there were misrepresentations, if they weren't at least reckless, there's still no disciplinary violation here. And really, I think the recklessness opinion is the most precedentially troublesome and legally incorrect part of the committee report. As we explained in our briefs, there's two lines of cases the committee was drawing on for recklessness involved trust accounts, where a lawyer is reckless as to what's into his trust account or her trust account, but doesn't intentionally misrepresent it, and which aren't even 8.4 cases. And then there are 8.4 cases involving false statements that weren't intentionally false, but the lawyers kind of didn't care if they were false or not. The hearing committee took that and converted that reckless standard from recklessness with respect to truth or falsity to recklessness with respect to particular factual consequences like resignations and riots in the streets, which the Court of Appeals has never countenanced, and which really do try to force the bar discipline process into a sort of second guessing of policy decisions in the executive branch. Perhaps it's arguable that the risk for resignations outweighed any benefit the letter would have given to anybody. That's not this board or any other board's decision to make. Yet the committee, hearing committee, took upon itself to make that decision as a predicate for its violation. And we do need to think about what effect that's going to have on as Mr. Gilbertson, I think, is focusing on with Mr. Fox, on the government officials going forward. I still don't, even today, don't understand Mr. Fox's theory. It's been described as excessive persistence. It's been described as some kind of a continuum. Mr. Hirsch thought the violation didn't spring into existence, which I agree didn't make a whole lot of sense to me either, for the opposite reason, until January 3rd, and not even at the beginning of that meeting, not to the end of that. Mr. Fox thinks it was somewhere in between. What are government lawyers to do when arguing for their views with their superiors, with the president? When do they cross the line from creative thinking and aggressive advocacy and outside the box into excessive persistence or some kind of blameworthy continuum? What if somebody does threaten to resign? Is the lawyer who proposed the idea that prompted it to say to himself, wow, am I being reckless here? My law license back in whatever state might be put in jeopardy? It absolutely, immunity aside, is going to have a chilling effect on internal discussions, not just in the Department of Justice, but throughout the executive branch. That question has remained unanswered throughout these proceedings and has yet to be answered today. And that actually, I'll have to stop in time for questions, leads me to what I haven't talked on today, is the question of sanctions. Obviously, we don't think the board needs to reach that question, but if it does, an important consideration is we contend Mr. Clark was not given fair notice, and there won't be a clear line for future lawyers to go by. And there's a couple good examples from the Court of Appeals' own precedent of an approach it's taken. One is In re Klein, where the court held for the first time that the rules of ethics inform the prosecutor's duty to present Brady evidence. And that was a subject of some debate. And so that particular prosecutor wasn't sanctioned in any way. There was a recent case, I think from the summer, about flat fees, where the Court of Appeals made the same ruling. And the case involving the former Attorney General Mitchell that I described a moment ago, not in the discipline context, obviously, but sort of took a similar approach, where he wasn't found to be liable for what was only later found to be a violation. So all that by way of saying, if there is some kind of disciplinary sanction sustained here, the appropriate action we take is to give some kind of a clear instruction, which the ODC has not offered, to the government about what they can and can't do. At most, maybe give some kind of an admonition to Mr. Clark if there's some concerns the board has, but to do not impose discipline on him at all. We think assuming a violation, that would be the appropriate result. I see I have 6 seconds remaining. Are there any other questions? Thank you.
Thank you. So this matter is submitted to the board. Thank you very much, counsel.